Do I need to pay transfer taxes when transferring title? Transfer taxes can significantly increase the cost of transferring Manhattan real estate. Transfer taxes apply to most real property conveyances in Manhattan and throughout New York when the consideration exceeds $500. Under New York Tax Law Section 1402, the state imposes a tax rate of $2 for every $500 of consideration, which equals 0.4% of the sale price. New York City also imposes a separate real property transfer tax on transfers exceeding $25,000. The NYC real property transfer tax rate ranges from 1% to 2.625% depending on the property type and sale price. New York transfer taxes are generally divided into state taxes and New York City taxes. The base New York State transfer tax applies to conveyances where consideration exceeds $500. For properties located in New York City, New York State imposes an additional base transfer tax of 0.25% when consideration is $3 million or more for residential property or $2 million or more for other property. New York State also imposes a mansion tax on residential conveyances of $1 million or more. The mansion tax starts at 1% and can reach up to 3.9% for properties priced at $25 million or more. New York State also imposes a supplemental tax on certain New York City residential conveyances of $2 million or more using a graduated rate schedule. For residential properties in New York City, the RPTT rate is 1% when the consideration is $500,000 or less. When the residential consideration exceeds $500,000, the rate increases to 1.425%. For commercial property in New York City, the RPTT rate is 1.425% when the consideration is $500,000 or less. When the commercial consideration exceeds $500,000, the rate increases to 2.625%. Transfer tax is usually paid by the seller, but the buyer may be required to pay if the seller fails to do so. Buyers are responsible for paying the mansion tax on residential purchases of $1 million or more. In New York, real property is transferred by means of a deed. The deed must be in writing and contain language sufficient to convey ownership from the grantor to the grantee. The deed must identify both parties and include a legal description of the property. The grantor must sign the deed and the signature must be properly acknowledged to be recorded. Once recorded with the Office of the City Register, the conveyance is protected against competing claims. A deed transfer lawyer can prepare, review, and record the deed to help ensure compliance with New York law. Title transfers commonly occur when adding or removing a spouse from a deed. Transfers may also occur when moving property into or out of a corporation, partnership, limited liability company, or trust. Property may be transferred from an estate to an individual in the case of inheritance. Each of these situations can carry different tax implications depending on whether consideration is exchanged. A gift of real property generally does not involve consideration and is typically exempt from transfer taxes. However, under New York Tax Law Section 1401(d), consideration includes the cancellation or discharge of a debt and the assumption of a mortgage. If a property is gifted with an outstanding mortgage, the mortgage balance is treated as taxable consideration. Both the New York State Transfer Tax and the New York City Real Property Transfer Tax may apply to the outstanding mortgage amount. Certain transfers may qualify for reduced or eliminated transfer taxes depending on how the transaction is structured. Transfers without consideration, such as a straight gift with no mortgage attached and no debt assumed, are generally exempt. Transfers between certain family members as part of estate planning may also minimize tax exposure when properly structured. Even when a transfer is labeled a gift, assumption of an existing mortgage can trigger transfer tax liability. Cooperative housing transactions involve the transfer of shares in a corporation rather than a deed. New York State rules provide that the transfer tax can apply to transfers of cooperative housing stock shares connected with a proprietary lease. New York City also imposes RPTT on transfers of cooperative housing stock shares. The seller is generally responsible for paying transfer taxes on real property conveyances. Certain entities are exempt from paying transfer taxes, including the United States government and its agencies. New York State, its agencies, and political subdivisions are also exempt. Foreign governments and certain diplomatic representatives may be exempt when property is used exclusively for diplomatic or consular purposes. Some transactions are exempt from the tax but still require filing an RPTT return. Failing to pay the transfer tax can result in serious financial consequences. Under New York Tax Law Section 1416, late filing or late payment can trigger a penalty of 10% of the tax due. An additional 2% per month may apply after the first month, up to a maximum total penalty of 25%. The NYC Department of Finance may place a tax lien on the property for unpaid transfer taxes. A lien can prevent the owner from selling or refinancing the property. If the transfer tax is not paid, the Office of the City Register may refuse to record the deed. An experienced attorney can help calculate transfer tax obligations, prepare required filings, and work to minimize tax exposure where the law allows. Working with a knowledgeable lawyer can help avoid penalties, liens, and delays that complicate a closing. Sishodia PLLC is a New York law firm focused exclusively on New York real estate law and handles deed transfers for condos, co-ops, and multifamily properties across Manhattan and New York City. To speak with a deed transfer attorney about your situation, contact Sishodia PLLC at 833-616-4646, located at 600 3rd Avenue 2nd floor, New York, New York, 10016, United States.